After withdrawing the Personal Data Protection Bill 2019, the Government of India released a draft Digital Personal Data Protection Bill for public consultation on 18 November. The previous bill was based on the draft submitted by Justice B.N. Srikrishna Committee set up to assess personal data and its protection. Based on the draft and the interministerial consultations, the PDP bill was tabled in the Parliament in December 2019. What did the bill hold? The bill aimed at protecting personal data of individuals and their rights to privacy by bringing in regulations to oversee the manner in which personal data is processed, as well as for remedies or penalties for people who have been affected by data breaches, unlawful processing of data, and so on. It was withdrawn after the Joint Parliamentary Committee tabled its report after deliberating for 2 years. The government has reworked the Data Protection Bill, taking cues from the report submitted by JPC. We will see now why it is important. While the country is witnessing a digital revolution by adding more and more users to the internet, social and economic activities have surged online. With these services, there is an enormous generation of data which is collected, organized, and processed directly or as a critical component of their businesses. The phrase, "the world's most valuable resource is not oil but data," is increasingly becoming true, and those who control data control humanity today. While we reap its benefits, there are legitimate concerns about how tech companies are exploiting what they know about their users. Although India has regulations in place with the IT Act 2008 dealing with handling personal data and information, it does not offer a comprehensive data protection framework. It is left behind when compared with the likes of European Union, which has comprehensive guidelines laid down for processing and storing data, which includes the intermediaries and the trans-border data flows. Why does it matter? The data breach by tech giant Facebook, now known as Meta, involving a British consulting firm Cambridge Analytica, shows the enormity of the need for data protection. Personal data belonging to millions of Facebook users was collected without their consent and was used to create psychological profiles. Data harvested was used to provide analytical assistance during the 2016 US presidential elections, and even allegations of interference in the Brexit referendum was made. It begs for a serious examination of data sovereignty and confidentiality when big data can be used against countries and people as a weapon. Not just limiting its use to political consulting, many advertisers have made similar tools for targeting advertising by harvesting this data from the users. It is just an example of a singular event from the myriad of scandals breaching the data and privacy of users worldwide. Some of the key takeaways from the revised draft bill are: the user has a right to consent for their data to be shared with the organization for processing, and also the right to withdraw consent, including knowing the type of data collected. Users have a right to demand the erasure and correction of the data collected by the organization. They also have a right to nominate an individual to exercise these rights in case of their demise. The bill proposes to set up a data protection board to ensure compliance. In case of an unsatisfactory response from the organization, the user can file a complaint to the board. The bill imposes significant responsibilities on organizations to ensure data is processed, stored, or erased in a safe and proper manner. It will also impose hefty penalties on businesses that undergo data breaches or fail to notify data breaches to the users when it happens. However, the framework no longer prescribes criminal penalties for non-compliance, but retains monetary penalties of up to 250 crores. Provisions regarding cross-border data transfers have been simplified to promote ease of doing businesses. It will also notify a list of countries to whom data can be transferred in accordance with the terms and conditions specified. According to the bill, the government can exempt certain businesses from following the provisions based on the number of users and volume of the data processed. It is understood to have been done due to the criticism received from the startups that the previous bill was too compliance intensive. The government has been empowered to exempt its agencies in the interest of national security and sovereignty and the integrity of the state and to maintain public order. It is viewed that Data Protection Bill is the only one piece that forms the part of India's larger policy vision for the entire digital economy. The larger policy includes a comprehensive Digital India Act that is set up to replace existing IT Act, Data Protection Bill and the new Telecom Bill too. As the draft bill is open for public consulting until December 17th, experts have opined on a few pain points in the bill ranging from lack of timelines to excessive delegation or lack of clarity in a few provisions. As the bill is in the nascent stage, it has to be seen the changes it undergoes until it passes the benches of the Parliament. Let us know your opinion on the Data Protection Bill in the comments section below.
Please subscribe to Nationalist Hub English channel for more interesting videos and don't forget to like and share this video. Nationalist Hub, it's a news revolution.